Good day, everyone, and welcome to today's program. At this time, all participants are in a listen-only mode. Later, you will have the opportunity to ask questions during the question-and-answer session. You may register to ask a question at any time by pressing the star and 1 on your touch-tone phone. You may withdraw yourself from the queue by pressing the pound key. Please note this call may be recorded. I will be standing by if you should need any assistance. It is now my pleasure to turn the conference over to Ms. Julia Duncan. Please go ahead, ma'am.
Hello, everyone. My name is Julia Duncan. I'm the Director of Federal Programs for the American Association for Justice. I want to thank you for joining us today to discuss the important issue of forced arbitration. As the groundbreaking investigation by the New York Times revealed, forced arbitration clauses are infiltrating every aspect of American life. These clauses, buried in the fine print of everything from cell phone and credit card terms and conditions to employment agreements and nursing home admissions forms, are forcing Americans to give up their constitutional right to access the courts, and most don't know it. The Times wrote, quote, "Over the last few years, it has become increasingly difficult to apply for a credit card, use a cell phone, get cable or internet service, or shop online without agreeing to private arbitration. The same applies to getting a job, renting a car, or placing a relative in a nursing home," end quote. The Times also quoted William G. Young, a federal judge in Boston who was appointed by President Ronald Reagan, as stating, quote, "This is among the most profound shifts in our legal history. Ominously, business has a good chance of opting out of the legal system altogether and misbehaving without reproach," end quote. Today we have a distinguished panel of experts to discuss the issue of forced arbitration and what can be done about it. We are honored to be joined by two members of the United States Congress, Senator Al Franken from Minnesota and Representative Hank Johnson from Georgia. Senator Franken and Congressman Johnson are longtime champions in the fight to restore consumers' access to justice. They are the sponsors of the Arbitration Fairness Act, proposed federal legislation that would prohibit forced arbitration from being used against consumers, workers, and patients, and also prohibit forced arbitration in civil rights cases. Also on today's call, we have Larry Powers, whose family has firsthand experience with forced arbitration in a nursing home setting. Mr. Powers will be joined by his attorney, Mr. Perry Shuttleworth. But first, for opening remarks, we will turn to Linda Lipson, Chief Executive Officer for the American Association for Justice. Ms. Lipson.
Good afternoon. Today, the New York Times published the second story in a three-part series on the insidious practice of forced arbitration. Forced arbitration is nothing more than a corporate bullying tactic designed to kick people out of court and eliminate their right to seek justice. It's rigged. It's for corporations by corporations. Hidden in the fine print of everything from credit cards and cell phone contracts to nursing home admission forms and employee handbooks, forced arbitration clauses are a free pass for corporations to steal and break the law. These dishonest agreements trick consumers into unknowingly signing away their rights to hold bad-acting corporations accountable in court. Instead, consumers are funneled into a process where an arbiter is chosen by the corporation, decides their fate. These arbiters are not required to follow the law, and their decisions are almost impossible to appeal. And they're actually incentivized to decide on behalf of the corporation so they can guarantee future arbitration contracts. Fortunately, regulators are starting to take notice. In October, the Consumer Financial Protection Bureau, the CFPB, announced the outlines of a rule to restore accountability for financial institutions like banks and credit card companies that use forced arbitration in their contracts. A week later, the Centers for Medicare and Medicaid Services closed a public comment period on a pending update of nursing home standards that recognize the burdens of arbitration on residents harmed by nursing homes. Both of these moves are a good step towards restoring consumer rights, but they can and should do more. The CFPB should strengthen its plan to ensure that all consumers, whether joining with others in a class action lawsuit or acting alone, have the right to hold corporations accountable when they break the law. The CMS should not simply acknowledge the problems of forced arbitration in nursing home contracts. It should ban the practice altogether. The American Association for Justice is committed to protecting people's rights to seek justice through our legal system when they are injured by the negligence or misconduct of others, even when it means taking on the most powerful corporations. We are proud to stand with Senator Franken and Congressman Johnson and others who are working to put an end to this insidious practice of forced arbitration. The practice of forced arbitration closes the doors to justice for millions of Americans and sets up an unfair, secretive system that favors powerful corporate interests. It is the greatest violation of consumer rights and must come to an end. Thank you.
Thank you so much. Next up, we have Senator Franken.
Hi, everybody. Thanks for joining on this call. It says here in my talking points I was supposed to go, thank you for that kind introduction, but you just said next is Senator Franken. So I'm not really, I don't think that was such a great introduction, but I'll take it. Anyway, I don't know if any of you have read the last 2 days in the New York Times, the articles on the first it was top of the, above the fold lead article yesterday, Sunday. And Sunday New York Times is very popular for, especially in New York, for getting like a bagel and a schmear and some lox and then reading the New York Times. So you should it's a very reputable paper is what I'm saying. And they did this thing on something that I've been focused on for a long time, which is the use of mandatory arbitration. Now, what does that mean? This is pre-dispute. Mandatory arbitration. That means when you sign the contract, somewhere buried in the contract, whether it be a consumer contract or employee contract, there's a clause that said, if we have a dispute, you can't go to court. You have to go to arbitration. And the arbitrator, well, we pick the arbitrator. And this is really been decided by a number of 5-4 decisions. When I first came to the Senate, I got there a little late. You might remember I had a close election. And Harry Reid put me on the Judiciary Committee, and I said, Harry, I'm not a lawyer. You might notice there are a lot of lawyers around here. He said, well, that's why we want you here. And he was kind of BSing because that was the only seat he had for me left. I was the last guy there. But I started seeing how unbelievably unfair these mandatory arbitration agreements were. A number of women who had been, we know about sexual assault in the military, thank goodness now, that's come to light, but there's also been sexual assault among contractors like KBR and the others, where the employment contract has been, until I acted, has been a mandatory pre-dispute, mandatory arbitration clause where the woman could not go to court. And we had a case where a woman said she had been raped by KBR employees, and they would not let her go to court. And the problem with this is that when it goes to arbitration, it's all secret. So we had no idea what was going on with women in Iraq and Afghanistan with contractors. So we had a hearing on this, and ultimately she got to go to court because we passed a thing saying that contractors, military contractors, Department of Defense contractors can't get a contract if they have mandatory arbitration agreements that apply to rape, to sexual assault, wrongful imprisonment, violation of civil rights. So we prevailed in that one. But we had a hearing here, and she got her trial, and she lost. She lost in the courtroom. But the point is, other women now can go. And now we can know a little bit more what was happening there. Anyway, we had a hearing, and I asked the guy who was there to represent those who believe we should have mandatory arbitration agreements, and he said something. He had something in his testimony which was saying a majority of people prevail in these arbitration hearings. And so I asked him if someone was sexually assaulted and got $100, would that count in your statistics as prevailing? And he said no. And I said, okay, how about $200? Oh, at $200 he said he didn't know. And I said, well, how did you know at 100 if you don't know at 200? And he was BSing. And I've had 3 hearings on this. And these corporations and the Chamber of Commerce, who like it the way it is now, I would ask you to watch a hearing I did on December 2013 and go to 1 hour and 55 minutes. And the lawyer who was there, professor from the University of Georgia, I asked him about a case, which I think may have been the case, or one of the cases they're referring to in today's New York Times, because it had a lot of the same facts, was a woman doctor who went to work for a hospital or a healthcare group and did not get a promotion. She noticed that they did not promote women. They just had a record of not promoting women, so she wanted to go to court. And they had a mandatory arbitration agreement. So she went to the arbitration agreement to a law firm, which the room she was in with the arbitrator was lined with books with the name of the health group or hospital on the shelves. And she knew the fix was in. And of course she lost. And she said she had lost faith in the American justice system. So I asked this witness for the Chamber of Commerce, the witness from the University of Georgia, I said, what would you... I also quoted an article that he had written before he worked for the Chamber of Commerce, saying that these arbitrators try to get a reputation of being pro-industry because then they get hired more. So I said that was clearly what was happening here. The fix was in. What would you tell? You go to 155 and you'll see this. I say, what would you tell this woman? And this is an hour, 55 minutes, not a minute, 55 seconds. He said, I'd tell her to go to court. And I said, that's what we have been talking about for the last 2 hours. She can't go to court. There's a mandatory arbitration agreement. That's the whole point of this the last 2 hours. I was off by 5 minutes, evidently. This guy then had the nerve of trying to change the subject and say, well, because we were talking also about the Italian colors decision, in which the court on a 5-4 basis said that you couldn't even get to court where there was no possible reasonable way that you could recover your losses, that was worth covering your losses if you got tricked or by a corporation. It was Italian Colors, the restaurant. So, and that was about credit cards. That was American Express. Italian Colors versus American Express. This lawyer who said, well, look, it hasn't happened that this whole parade of terribles that you said that everyone said would happen because of this. Go to this chart in the CFPB, the Consumer Financial Protection Bureau's report on this. You got that chart on page 41 or whatever it was? I said, yeah. He said, well, you see that in the circle, only 17% of credit card companies or credit cards have gone to mandatory arbitration agreements. So this hasn't really happened the way people would say. As 17 out of 100 and some. And I said, I said, what percentage of the business in credit cards does that 17% of the companies have? And he said he didn't know. And I said, okay, well then I'll ask this lawyer from this other witness from the Cardozo school, and then he went, it's 94 to 98%. He knew. These guys are bad guys. And I have an Arbitration Fairness Act that I reintroduced. I introduced it first in April of 2014. I'm reintroducing it. But everything you've seen in the New York Times, I have reintroduced it. Everything you're seeing in the New York Times is what this is about. And it's about giving the right of people to go to court, to get to court. It's in the Constitution. It's in 2 amendments in the Constitution, in the Bill of Rights. The Second Amendment is important. That's 1 amendment. Juries are really important. That's 2 amendments. And in 5-4 decisions, you'll see in the first article in the New York Times, it talks about what John Roberts was doing when he was a lawyer for these corporations. So the CFPB and CMS, which handles Medicare, which oversees Medicare and Medicaid, are involved in rulemaking now. And we want to make sure that these rules are seen under the proper light. And that's what this call is about. That's why we have members of the press on. This is about lawyers like the one I cross-examined at that hearing, who before he was hired by the Chamber of Commerce sang a very different tune, told the truth. And then, subject to questioning, couldn't until he was forced to. So I don't have any strong feelings about this, understand. But we want you all to read the New York Times and to keep talking to us, and thanks for listening. Thanks.
Thank you so much, Senator Franken. Next to speak, we have Representative Johnson.
Thank you. This is Hank Johnson on the line. I want to thank Senator Al Franken for all of his efforts to bring an end to forced arbitration. The exhaustive and thoughtful series by the New York Times cataloging the immense harms of forced arbitration should provoke the American people into action. Through a well-documented pattern of exploitation, forced arbitration has whittled away at the vital statutory protections in place to protect countless employees and consumers from discrimination, predatory lending, and just about every other exploitative activity in the realm of commerce. As overwhelmingly and methodically documented by the Consumer Financial Protection Board's 748-page report, forced arbitration restricts consumers' relief for disputes by limiting class actions, and the vast majority of consumers don't even know that they are subject to arbitration agreements. This issue has long been an interest of mine. My first experience was with a arbitration clause in an agreement came when I was looking at downsizing my house, and we wanted to build a new place, and the contract presented to us at the site of the new home had this arbitration clause in it. I found it to be disturbing, and so I asked whether or not we could take that out, and they said, no, all of our contracts are like this. And so that meant that if I wanted to build in that area, I was going to be subject to that arbitration clause. And since 2007, I've championed the Arbitration Fairness Act, which would eliminate forced arbitration clauses in consumer, employment, and civil rights cases. Beyond comprehensive legislation to end forced arbitration, I'm also working with agencies to end forced arbitration in specific areas. Earlier this year, I sent a House letter signed by over 55 members of Congress to the Consumer Financial Protection Bureau calling for a strong rule prohibiting forced arbitration clauses in consumer financial products and services. The Bureau has already found that forced arbitration clauses in financial services contracts burden consumers. It's also vital that the CFPB continue its important work through its rulemaking authority. Last month, I sent a letter to the Centers for Medicare and Medicaid Services concerning its proposed rule to reform requirements for long-term care facilities, specifically calling for an end to forced arbitration clauses in nursing home agreements. This letter, which was supported by dozens of my colleagues, noted that nursing home residents stand to lose access to the courts for every conceivable injury that they could suffer at the hands of unscrupulous caregivers and facility operators. It's critical that CMS rejects that well-documented harm which is associated with pre-dispute arbitration in favor of a final rule that empowers residents to arbitrate claims after they arise. Now, I can give you a personal experience also about nursing homes. My dad needed one after it became clear that he could no longer be treated at the hospital. I mean, his hospital stay had ended, and he could not go back to the personal care home where we had him living at that time. He needed a nursing home. And so it was literally about 24 hours notice that we had to scramble to find a nursing home in the area that would take him, given his situation, his financial situation, his physical and mental situation. And so there wasn't a lot of time, there wasn't a lot of leverage that we as consumers had. We had to go with pretty much what was out there, and if the only thing out there or everything out there included a arbitration clause, a forced arbitration clause, then there really is no choice, and it's done under a duress or coercive circumstance. And so this is a bad situation for nursing home residents to have to accept. And so I hope and expect that the important series in the New York Times is a wake-up call to all Americans that forced arbitration is not voluntary, it's not just, and it's simply not fair. And in essence, it's really un-American. I'll continue to fight to end forced arbitration, and I hope that this series provides the ammunition for millions of Americans to fight along with us to end this scourge on the American people. And with that, as we say in the House, I yield back.
Thank you so much, Representative Johnson. Next, we have Mr. Larry Powers and his attorney, Mr. Perry Shuttleworth.
Okay, my name is Larry Powers. I'm the oldest child of Roberta Powers, and our mother birthed a total of 5 children, 3 girls and 2 boys. Ms. Powers was diagnosed with diabetes mellitus, carcinoma of the breast, and in 2008, Alzheimer's disease. That disease progressed to the point that mother was no longer able to live alone in 2011. Mother's children researched all the available nursing homes and assumed we had selected a top-notch home that would provide and monitor mother's health needs. However, it was revealed from an autopsy report that mother had an overdose of metformin in her system. She had 28 milligrams, and the normal would be 5 milligrams. It was later discovered that mother was also dehydrated, which caused the overdose of metformin. Therefore, if mother had been appropriately monitored, hydrated, there would have not been an overdose of metformin in her system. Perhaps she would have been here to witness the birth of her 5th great-grandchild in December of this year. Therefore, the children of Mrs. Powers would like to seek justice for other families that face the same or similar situations in the association of the arbitration agreement. The arbitration agreement fails to promote accountability, and without accountability, substandard services will continue in the future. Thank you.
This is Perry Shuttlesworth. I'm the lawyer for the Powers family, and first I'd just like to say that it was an honor representing the Powers family. They're some of my favorite clients over the course of 25 years as a lawyer. This was a case that involved a lady who was a very active and healthy nursing home resident. You know, she frequently went out of the facility to go to church on weekends, was very active in social activities, at the nursing home, had a very high quality of life. And the reason that I raised that is, as a lawyer who does a lot of nursing home neglect and abuse work, one of the favorite defenses of the corporate lawyers in these cases is that, well, they were old and had no quality of life anyway, which is never a good argument in my opinion. But in this instance, this lady had a really high quality of life and was rather healthy. Her death was absolutely avoidable. It was not some long, drawn-out, fatal condition that she was suffering from. She was really preparing to go to her great-granddaughter's birthday party, when she was found in this condition with pills. And the reason that the physician at the University of Alabama at Birmingham Emergency Department actually ordered an autopsy in this instance was because pills were actually found by the family, and that information had been related to the physicians. And lo and behold, upon doing a toxicology report, they found 20 times the amount of the drug in her system that should have been there given the therapeutic dose of the drug, clearly an overdose. But in this situation, and because of the nature of arbitration, we present our cases. And I'll say this, that these are very difficult cases to begin with. The Medical Liability Act in Alabama and also in Georgia, where I also do a lot of work, they're very, very difficult cases because of the burdens imposed upon medical liability cases that require us to spend tens of thousands of dollars, sometimes hundreds of thousands of dollars, hiring experts to testify about the conduct of the nurses, physicians to testify as to whether or not the negligent conduct was the cause of death, and so forth and so on. So we screen these cases incredibly carefully, and only the ones, I would say less than 5% of the cases that we look at actually make it to the stage where we file a claim. So this was a case where we had a lot of very, very compelling evidence. And I would say that about all the nursing home cases that we file. In this instance, like in any other arbitration matter, because the arbitrator has no appellate review, there is virtually no appeal. They can do absolutely whatever they want. They're being paid 100% in this instance by the defendant corporation or their insurance carrier. So there's an inherent conflict of interest. So they can go in, as they did here, and basically look at a mountain of evidence, whether it's both documentary evidence, the medical records, expert testimony, the outcome itself, toxicology reports from the hospital. They can look at all of that, and if they choose to do so in order to keep their business coming from the corporate interest in their insurance companies, they can listen to one nurse say, "We took good care of them." And that's good enough for them. And that's precisely what has happened. And when I say that, when I say precisely, I mean literally what happened in another case I had in front of JAMS this year. But that's essentially what happens in all of these cases. There is it is a predetermined outcome based upon a conflict of interest. They have every reason to help their corporate colleagues by giving them a judgment in their favor. They keep the money. The corporate defendants are able to basically continue to place higher profits over human life. So they don't get held accountable for their conduct, and the arbitrators get to keep the business flowing. So it's a perfect setup for them. For nursing home residents, it's a nightmare, and for their families, and because it's a nightmare for the Powers family because they could not hold these people accountable, for the death of their mother, and what's worse. In some sense, or in one sense, is that moving forward, after a trial or after an arbitration, a defendant is going to go back to the boardroom and they're going to sit down and they're either going to go, "Wow, we really have to do something different, right? We've got to clean up our act, start forgetting about billing so much, hire some more people, perhaps, train our nurses better, do a better job of caring for these people." Because if not, we're going to have to pay out large judgments because we've been held accountable for putting profits above life. In this situation, they go to the boardroom and they have champagne, and they're happy as they can be because they got away with it again, and they know it's going to happen again and again and again, and they don't change anything. So the poor people out there right now who are, as we speak, signing admission agreements have no idea what they're getting into. They have no idea that these folks have no incentive to really do better, to provide good care, because they know that they won't be accountable for not doing so. One last thing I'd like to say is this. The end result for us and the legal community is that there really is only a small group of us who do nursing home cases to begin with, because they are complicated, they're difficult, they're expensive, and they're risky. There's a handful of us who do these cases because we believe in them. And really and truly, if you do some, if you're a lawyer who's so inclined to handle this type of work, it's hard not to do some of them and see how some of these folks are treated, and not become very endeared to this population of people and to want to continue to do it. The problem is when you go and you lose $50,000 or $100,000 in expenses alone, not even counting your time, in trying to bring one of these cases, and you have an arbitrator look at you and just ignore the evidence and pat his buddies on the back, it's a very, very difficult thing for us to do in order to be able to sustain a business where we represent these people. So ultimately, that's the bigger concern in this little piece of the puzzle of the bigger arbitration picture, is that especially when you add the medical liability piece to it, it's very difficult moving forward to try and find a situation where you can represent these folks and still stay in business. And they know that. That's the nursing home, the healthcare community knows that. And of course, that's what they'd like to accomplish. But anyway, I could go on for days about this stuff, obviously. But I appreciate very much what the New York Times has done in bringing this to the light of day. And I also appreciate the efforts of Representative Johnson and Senator Franken. And with that, that's all I have. Thank you very much.
Thank you so much. I'd like to thank each of our speakers for their comments today. We'd now like to start taking questions. Operator, can you please move into the question and answer session of the call?
Certainly. At this time, if you would like to ask a question, you may press star and 1 on your touch-tone phone. Again, that's star and 1 on your touch-tone phone. If you find that your question has already been answered, you may remove yourself from the queue by pressing the pound key. And we'll go ahead and take our first question from Lydia Wheeler with The Hill. Please go ahead. Your line is open.
Yes, thanks so much for holding this call. I am wondering if this legislation that's been introduced in the House by Representative Goodlatte is going anywhere, the Fairness and Class Action Litigation Act of 2015. I'm wondering what the lawmakers have to say about that piece of proposed legislation and if that's getting any traction in the House.
Well, I'll yield to Hank.
Yeah, this is Congressman Johnson. The House is caught up in gridlock right now, and I don't really expect much to pass out of this session of Congress other than perhaps some weak form of criminal justice reform. As far as the legislation you referred to, Congressman Goodlatte's, it's passed out of committee, but it has yet to be brought to the floor. I'm not sure of the sentiment of the majority of members of the Republican caucus, but I would assume that they would be amenable to that legislation and supportive of it. But whether or not it makes the House floor or not remains to be seen.
I don't know, Hank. Well, I don't know that legislation. So can you tell me what's in it, or because generally I've had hard time getting, Republican colleagues to sign on.
Senator Franken, this legislation is designed to limit class actions for Americans, and the New York Times story that shed light on the fact that it is the only tool that consumers can use when they're ripped off in small amounts. So instead of spending the time focusing on...
So this is an anti-class action.
Yes, but
but what do they call it? What's the name of the thing?
Fairness and Class Action Litigation Act of 2015.
Right, which is the opposite of what it really is.
Right, of course.
The opposite of what it really is. Well, but instead of spending the time focusing on forced arbitration and making it ending this secretive, rigged practice, instead they're spending time trying to limit the use of the only tool that works effectively for consumers.
The fact of the matter is that the history of this is that when the first arbitration laws were passed, mandatory arbitration, they were really about corporations to corporations, and that the legislative history of that is pretty clear. And this has been swept up in consumers and employees, and that's not an appropriate role for this. And obviously, this Roberts Court is a very pro-corporate court, and there's no question about it. And it's a very activist court. All you have to do is look at the Voting Rights Act, and they're striking down the formula for preclearance on that. This has all been activist decisions, and we're trying to get this back to the original intention of the law. And so it doesn't surprise me that Goodlatte's legislation is moving in the wrong direction.
Thank you so much. Operator, are there any other questions in the queue?
There is. We can go ahead and take our next question from Jim Spencer with the Minneapolis Star-Tribune. Please go ahead. Your line is open.
Okay. Question is for Senator Franken. Senator Franken, thanks so much to everybody for doing the call.
Sure.
You've tried this twice now. This is your third attempt, and you were just saying in the earlier answer to the question before this that you were generally having a hard time getting Republicans to sign on with you. Do you have any expectation that you're going to be able to get this thing out of committee this year when you couldn't do it in the two prior years? And if not, what's going to be the way that this gets done? By rule?
Well, part of it is going to be the rules. CFPB and CMS are doing rulemaking now. So that is, and that's a proper role for both bodies, and we want people to know about this. New York Times has done this 3-piece article. I haven't seen the third part yet, but this is a massive way of ripping off consumers, of hurting employees, and it's wrong. And I'll give you another instance. We had a Minnesota soldier who had his house foreclosed on while he was while he was in Iraq, and that's against the law. And the bank that did it foreclosed on his house. You can't do this, and they filled out a thing saying he wasn't he wasn't deployed, and he was at Camp Anaconda in Balad, Iraq. He was defending our country, and they foreclosed on him. And then not only did they foreclose on him, but a buyer bought his house, for about a third of what it was worth. Guess who the buyer was? The bank that foreclosed on him. Yeah. So he knew that this was happening to other guys that he was serving with, and so he wanted to do a class action. But he couldn't. So instead, he could sue himself, or I think he sued because they lied. I mean, they actually lied on the form saying that he wasn't deployed. But the settlement is secret, and so we don't know how many other soldiers and Marines and airmen and airwomen and Coast Guardsmen were ripped off this way.
Can I follow up? Why would the rules work given what the Supreme Court has already decided?
Say that again.
Why would rule changes work given what the Supreme Court has already decided about the issue of pre-dispute arbitration?
Because they have the authority to make these rules. And so very often the Supreme Court what they decide can be fixed by some other action by another part of the government. Okay. That happens a lot.
Thank you very much.
Yeah.
Yeah, and in fact, this is Congressman Johnson. The Dodd-Frank law that passed 5 years ago gives this authority to this Consumer Financial Transaction Bureau to do exactly what they are in the process of issuing a rule about. Section 1028 of the Dodd-Frank Act in particular, or specifically, is what gives the CFTP the authority to do what it is doing. And so, of course, anything that they do will be subject to challenge, both legislatively and in the courts. But, the bottom line is we need to get as far as we can with what we have available right now, with the tools that we have available right now, while continuing to fight legislatively to correct the U.S. Supreme Court's, in my opinion, erroneous rulings in both Concepcion and Italian colors.
And that's
that's going to require us to turn out this current crop of Republican-led free market conservatives. This closing the courthouse doors, limiting litigation to which is really a check and balance on corporate excesses. This is what Republicans do. This is what they're known for. This is what their brand is. And so we're going to have to change, how the legislature functions in this country and what its priorities are. And the only way we can do that is to change the the makeup of this current legislature, and I don't want to turn it into a partisan issue, but I will say that this current crop of free market conservatives who rule Congress right now, the American people are going to have to get fed up with it, going to have to see through it, and going to have to understand that what these folks are promoting is not in their best interest. This protects the top 10% and, in fact, the top 1% of earners in this country, shielding them from lawsuits, protecting the wealth that they are building, which comes from the pocketbooks of everyday working Americans. And they take it one penny, $1, one $10, one $25 at a time. They make it such that regular people can't afford to take an individual claim to court to redress a wrongdoing by a large corporation with hundreds of millions of subscribers or customers.
Hank, I'm going to have to go. I want to thank you for clarifying where that authority came from, which comes from Dodd-Frank for Jim Spencer and me to cite that specific authority. If there's one more question that I could dispense with, if someone has a question for me or for us that I could dispense with pretty quickly, that would be good. Otherwise, I got to go.
I think there are no more questions in the queue. So at that point, we want to thank everybody for calling in and for our speakers for their very thoughtful comments. Thank you so much.